Oh, hi, welcome. I'm here just to give you a brief history of workers' comp appellate jurisdiction. Until 1979, JCC orders were reviewed by something called the Industrial Relations Commission. And then from there, they could be reviewed in the Florida Supreme Court. But on October 1st, 1979, the legislature enacted Section 440.271 to put exclusive jurisdiction of all workers' comp appeals in this court, the First District. So that means statewide, all of the JCC orders, if they're appealed, they come here to us. That means that legislative change in 1979 means there's no interdistrict conflicts. Combined with constitutional amendments that went through in 1980, that made it such that there's very few cases ever get to the Florida Supreme Court, notwithstanding recent history. The Florida Supreme Court review is very rare, so that means effectively we're the court of last resort for workers' comp appeals. So with that responsibility, the court realized that they could enhance the uniformity of the workers' comp case law and process cases faster by creating a dedicated law clerk unit to handle those appeals. With the old way, the clerks who work in each judge's suite would see workers' comp cases, but with 15 judges and twice as many law clerks, it was few and far between for each given clerk, not to mention the turnover upstairs. Some clerks are term clerks. They're only here for 2 years. So they had limited experience with workers' comp. The proposed opinions were circulated only among the 3 judges who were on that panel, not even necessarily their law clerks, sometimes. So no one else saw those until pre-release, where the people here just proofread it. That created an obstacle to identifying related issues, created a greater potential of conflicting decisions and opinions. But in 2008, we created this dedicated workers' compensation unit. So we have a lot of experience, we have a lot of expertise. The 3 of us here, Wilbur when he was here, we have more experience, we have low turnover, comp is all we do. We are able to circulate proposed opinions among ourselves when the judges choose to share them with us. So we see them as well as the judges. We can identify related issues earlier and more frequently, and we have a greater potential of getting it consistent and uniform so that the bench and bar can understand better what the law is.
Sarah, is it just the 3 of you?
Yes. Right now, yes. So we're good, though. We got a lot of expertise. We got enough work to do. Keep them coming. Yeah. Processing cases. We get to touch the case at a lot of different points in its journey through the First District. When the notice of appeal is filed, we screen that for jurisdiction. It's screened by our director, Todd Sanders. He is looking for timeliness of the notice of appeal. He's looking for finality of the order. And if it's an extraordinary writ, it's not a notice of appeal, it's a petition. He's looking to see whether there's alleged real irreparable harm on the face of that petition. If there's not, he'll ask the court to issue an order to show cause why the case shouldn't be dismissed. Assuming the case is okay there, the unit gets to see it again when the initial brief is filed. At that point, Todd will screen the initial brief for potential application of the summary affirmance rule. It's Florida Rule of Appellate Procedure 9.315A. That rule allows this court to look at the initial brief and start the summary right then and possibly issue an order that says there's no need for an answer brief. We think we got it here. We don't think this initial brief, frankly, has enough in it to sustain an appeal. What's nice about having this unit, though, is as we work through the summary, there's absolutely no barrier for this unit to suggest, well, maybe we do need an answer brief. It's very easy for us to do that. Assuming the case proceeds with an answer brief, at the answer brief stage, the case is sent to our unit to summarize for the judges upstairs. So we can work on the case while waiting for the reply brief to come in. As the reply brief comes in, that enhances the efficiency, again, with which these cases are disposed. We draft a summary, we summarize everything, do some research, we make a recommendation. They certainly aren't bound by them, and they know that, but that gives us a nice touchstone to say, how can we write this? Once the final brief is in, usually it's the reply brief, the case is perfected, we call it. It's reviewed, our summaries are reviewed and finalized by our director, Todd. They're proofread and hyperlinked by our administrative assistant, Nina. And they're hyperlinked to our record sites so that the judge is just one click and they're right there at that spot in the record. At that point, they're sent to the clerk's office for immediate panel assignment. There are potentially 455 distinct panels here. So it's really a toss-up as to which panel will get it. But it's whichever is the next panel up. So again, enhancing the efficiency. Finally, at that point, the process just proceeds as it would for any other merits case. The primary looks at it first, the primary judge agrees or disagrees with the recommendation. From there, it goes to the most junior of the other two judges on the three-judge panel. So there's no peer pressure. Then it goes to the third judge. They may confer about the case in person or by email. They may issue an opinion. I think it's real important, though, for practitioners to realize that post-opinion motions do not come to our unit first. They go to the primary judge's suite at that point. The case is the responsibility of the primary judge. The primary judge has the discretion to share that with our unit or not. Often they do, which we love, but just be aware that at that point, it's that panel. Next, Todd